Months after former President Donald Trump announced a sweeping travel ban targeting 12 countries, the potential consequences for those seeking green cards in the United States have begun to attract significant attention. While the initial ban received widespread media coverage, recent reports indicate that the U.S. Department of Homeland Security is now reviewing draft policies that could impose new limits on permanent residency applications, specifically affecting nationals of countries already included in the travel restrictions. This development, still in draft form, could dramatically reshape the path for many aspiring immigrants who had previously relied on existing immigration channels to achieve permanent residency in the United States. The countries affected by the original ban primarily included Afghanistan, Myanmar, Chad, the Republic of Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Libya, Somalia, Sudan, and Yemen, creating a broad and complex impact on thousands of families seeking to live and work legally in the United States. Additional restrictions were also applied to citizens of Burundi, Cuba, Laos, Sierra Leone, Togo, Turkmenistan, and Venezuela, though these did not amount to a complete ban but rather limited access to tourist or student visas and complicated permanent residency pathways. Former President Trump justified the initial travel ban by pointing to domestic security concerns, citing specific incidents that highlighted vulnerabilities he argued were tied to insufficient vetting procedures. He emphasized that individuals from certain countries were statistically more likely to overstay their visas, suggesting that tightening immigration rules was a necessary step to safeguard national security. However, critics argue that the policy unfairly targeted individuals based solely on their nationality, with little regard for personal history or individual merit. While the travel ban carried several exemptions, including provisions for those holding valid visas or green cards, athletes participating in global sporting events, Afghan nationals eligible for special immigrant visas, and religious or ethnic minorities facing persecution in Iran, the new draft policy appears poised to extend scrutiny to future green card applicants from the same set of countries, potentially making the process far more restrictive and unpredictable. The implications of these potential changes are profound, especially for immigrants who have already established lives in the United States. Many of these individuals have built careers, raised families, and contributed to their communities, yet the prospect of additional restrictions could create uncertainty about their ability to remain in the country permanently. Legal experts have expressed concern that a policy focused on country-specific factors could represent an unprecedented shift in how the U.S. evaluates green card applications. By prioritizing nationality over individual circumstances, the draft proposal may effectively introduce a tiered system in which applicants from certain countries face heightened scrutiny, while others continue to experience the traditional, relatively standardized immigration process. Former officials at the U.S. Citizenship and Immigration Services have publicly criticized the approach, describing it as an escalation of Trump-era immigration policies and warning that it could undermine the principles of fairness and equal opportunity that have historically guided U.S. immigration law. For those planning to apply for green cards in the near future, these developments underscore the importance of staying informed about evolving regulations and understanding how potential policy shifts could affect eligibility and processing times. Immigrants from affected countries may now need to prepare for more rigorous background checks, extended review periods, and a higher likelihood of case-specific hurdles that could delay or complicate their path to permanent residency. The draft policy also raises questions about broader administrative priorities, including how the government balances national security concerns with humanitarian commitments, the economic benefits of immigrant labor, and the social contributions of individuals seeking to build permanent lives in the United States. Observers note that while the policy remains unofficial, its mere consideration signals a continuing influence of the former administration's approach to immigration, even under a different presidential administration. The conversation around green card restrictions is not just a legal or bureaucratic matter, it carries profound personal and emotional significance for affected individuals and families. Many immigrants have devoted years to navigating the complex U.S. immigration system, only to face the prospect of additional barriers tied to factors outside their control. The possibility of new limits based on nationality could create a climate of uncertainty that affects educational plans, employment opportunities, family reunification, and long-term life choices. As a result, advocacy groups, legal professionals, and immigrant communities are paying close attention to the drafting process, urging policymakers to consider fairness, transparency, and the human impact of any new regulations. They argue that while national security is undeniably important, policies should not punish individuals for the circumstances of their birth or force families to face unnecessary hardship in pursuit of legal residency. In addition to individual impacts, the potential policy changes could also affect broader immigration trends and international perceptions of the United States as a destination for permanent residency. If green card eligibility becomes increasingly tied to nationality, prospective immigrants may reconsider their plans or seek alternatives in other countries that offer clearer, more predictable pathways to permanent residency. This could have long-term implications for U.S. labor markets, higher education institutions, and communities that rely on the contributions of foreign nationals. Furthermore, the international community will likely scrutinize the policy for compliance with human rights standards and principles of non-discrimination, raising questions about the global reputation of U.S. immigration policy in the decades to come. Analysts suggest that maintaining transparency and clear communication about any policy changes will be critical to ensuring both domestic and international confidence in the immigration system. Despite the uncertainty surrounding the draft policy, it is clear that the debate over immigration and green card eligibility remains highly charged and politically significant. Supporters of stricter rules argue that heightened scrutiny is essential to protect national security and ensure that individuals seeking to enter the United States meet rigorous standards. Critics, however, contend that country-specific limitations risk unfairly targeting law-abiding individuals and families while doing little to address the root causes of security concerns. This tension highlights the delicate balance policymakers must strike between protecting national interests and maintaining a fair and equitable immigration process. In practical terms, this means that any final version of the policy could significantly alter how USCIS evaluates applications, sets eligibility criteria, and prioritizes cases from different countries, creating a ripple effect across multiple sectors and communities. For green card applicants, the potential changes emphasize the importance of careful preparation, legal guidance, and staying informed about policy developments. Applicants may need to provide additional documentation, anticipate longer processing times, and be prepared for heightened scrutiny based on nationality. Families may also face new challenges in coordinating travel, work, and educational plans, particularly if processing delays or denials occur unexpectedly. While the policy is still in draft form, the mere possibility of implementation has already generated concern and debate among legal experts, advocacy groups, and immigrant communities, highlighting the high stakes of any changes to U.S. immigration policy. As the government continues to review the draft proposal, observers will be watching closely to see how it evolves and whether it ultimately reflects a continuation of Trump-era restrictions or a more balanced approach to national security and immigration fairness. In conclusion, while the draft policy remains unofficial, its potential impact on green card applicants from affected countries cannot be understated. By introducing country-specific considerations into the application process, the United States may be moving toward a more restrictive, complex system that alters the trajectory of countless aspiring immigrants' lives. As policymakers, legal experts, and immigrant communities continue to debate the merits and consequences of such a policy, the stakes for individuals and families remain high. Those considering applying for green cards must stay vigilant, informed, and prepared for potential changes that could shape their future in the United States. Whether the policy ultimately takes effect or not, the discussion underscores the ongoing tension between national security, fairness, and the United States' historical role as a destination for immigrants seeking opportunity, safety, and a permanent home. This evolving story will continue to be closely watched by millions both inside the United States and around the world, as the balance between immigration control and human rights remains at the forefront of national debate.